Judicial review? Constitutional? I don't get it!
Have you ever had problems like this? Because in this presentation, my team and I intend to explore the structure of judicial review as well as outline the effectiveness in terms of public bodies acting within the law. Now, a public body is that which exercises lawmaking powers or adjudicatory powers, and if defined in law and makes an error on the law, the courts, through the process of judicial review, shall intervene to ensure that the body in question reconsiders a matter and acts in a procedurally correct manner. The traditional view lies that the judge's task is to ensure that public bodies act intra vires, within their powers, and if the body has acted within these powers defined by statute or common law principles, the body's decision will not be challenged under this public law process. Therefore, judicial review is defined as a representation of which courts control exercise of governmental power, departments, local authorities, tribunals, state agencies, exercising powers which are governmental in nature in a lawful manner. If we're simply to put this down in layman terms, we can say that judicial review is in effect a judge-driven process as it stems from the common law.
So the basis for judicial review is under Section 31 of the Senior Courts Act 1981 and the Civil Procedure Rule 1998. An application to the High Court can be made for one or more on the following forms of relief, and it can be done in the order of mandamus, prohibition, and also an injunction or a declaration. And a declaration can be made or injunction can be granted where an application for judicial review seeking relief has been made to the High Court, and the High Court actually has to consider this. It is important to note that no application for judicial review shall be made unless the leave of the High Court is granted, and moreover, the applicant must have sufficient subject interest in the subject matter. So under the Civil Procedure Rule 1998, an action must be brought within 3 months of the decision against which the review is being sought. However, a shorter time period may be specified in the statute, and these must be complied with. The next important element of judicial review is the standing in which the questioning who can seek judicial review before an administrative court. For a person to claim under judicial review, there must be sufficient interest, basically meaning locus standi, in the subject matter, and there must be a connection between the claimant and the public law body. This ensures that there is no unnecessary claims that are brought before the court and prevents any floodgates.
Now, standing can be behalf on the interests of the members, and this would be professional bodies, trade unions. An establishment is in the case of R. Montpellier's and Trevor's Association and another versus Westminster City Council, where an association representing the residents of 2 squares in London successfully challenged a traffic order made by the Westminster City Council, which affected local residential areas. A further category that individuals can be affected directly by a public law decision is in the case of ex parte Binks. Binks was directly affected by the decision of the Ware Valley District Council to issue her with a notice to quit her takeaway food caravan without prior notice or any accompanying reasons. Individual busybodies, for example, a well-meaning citizen who is upset, for example, on Binks' behalf, would not be able to apply for judicial review to change the district council as they had already been directly affected. Lastly, groups or organizations who are acting on behalf of the public interest or in the public interest are other people that can seek judicial review. In R versus Secretary of State for Foreign and Commonwealth Affairs ex parte World Development Movement, the pressure group WDM successfully challenged the Foreign Secretary's decision to grant funding for the construction of a Malaysian hydroelectric station on the Peragawa River under the Overseas Development and Cooperation Act 1980 on the basis of it being economically unsound.
So judicial review is actually a tool that is given to judges to ensure that public bodies act within their respective areas. By providing judges with this tool, it actually brings in the concept of separation of powers. The idea of separation of powers suggests that the governance of the state should not fall solely under one organ. So basically, the state should be identified as the executive, the legislature, and the judiciary. So this actually puts the judges in a somewhat controversial position, as they are stuck between 2 duties. The first one being the upholding of the concept of separation of powers, and the second one being the monitoring of public body actions. So if the judges over-exceed their power given under judicial review, they would be crossing the boundaries of separation of powers between the legislature and the judiciary. So in this regard, it is up to the judiciary to uphold the concept and undertake judicial review in a careful manner. They should not cross the powers that has been distributed to them when performing the process of judicial review.
And with that said, we intend to discuss the level of effectiveness of judicial review in relation to public bodies. Kindly note that everything in this video is purely academic. Thank you.
Hi, today I'll be talking about illegality as one of the grounds of judicial review. So illegality occurs where relevant legislation does not contain the necessary power for the particular action carried out by a public body. That is, it is ultra vires. For example, a police officer is granted powers by statute to issue fines and carry out arrests with a warrant. However, if the police officer tries to sentence somebody to a jail term, then it is acting ultra vires. This can also apply to a passport officer, as seen in the case of Regina and Foreign Secretary ex parte Everett. A decision taken under the royal prerogative whether or not to issue a passport was subject to judicial review, or the relief was refused on the facts of the particular case. Taylor, Lord Justice, summarized the effect of the GCHQ case as making clear that the powers of the court cannot be ousted merely by invoking the word prerogative. The majority of their lordships indicated that whether judicial review of the exercise of a prerogative power is open depends upon the subject matter, and in particular whether it is justiciable. Illegality was defined by Lord Diplock in the case of Council of Civil Service Unions and Minister for the Civil Service. By illegality as a ground for judicial review, I mean that the decision maker must understand correctly the law that regulates his decision-making power and must give effect to it. Illegality can occur in many forms, namely simple ultra vires, wrongful delegation of power, improper purpose, abuse of discretion such as failure to exercise discretion, ignore relevant factors or take into account irrelevant factors, excess of jurisdiction, and breach of European Convention.
Now that we've established the grounds of illegality, we'll look into the second ground which an individual can claim judicial review, and that is the grounds of irrationality. The grounds of irrationality is highly concerned with decisions made by governmental bodies which are seen as unreasonable. Now, in order to fully understand and tackle the question of how the grounds of irrationality is able to control and regulate governmental powers, we must fully establish that the grounds of irrationality is highly concerned with intention of Parliament. That is, when there is a decision made which no reasonable man could come up with, it's seen as a contradiction to Parliament, as when Parliament devolved these powers, they mustn't have had these intentions in mind. Hence, it's important to reiterate that the grounds of irrationality are not concerned with it being a bad decision and we should change it, but rather it's unimaginable that any rational person would come up with the same outcome. Hence, it's seen as unlawful as it's outside the grant of powers. And that is how the grounds of irrationality can truly ensure that governmental bodies are working within their grant of powers. In order to succeed in claims of judicial review on grounds of irrationality, the Wensbury unreasonable test was what was looked to, and Lord Green said that as long as the decision was so unreasonable that no reasonable man could come to it, it will be seen as unlawful. However, Lord Diplock, in the case of CCSU, imposed a higher and more strict hurdle in order to claim on grounds of irrationality. In that case, he expounded that a decision which is so outrageous in its defiance of a logic that no man who applied his mind to it could still come to the same decision would be seen as an unlawful decision. Presently, proportionality has integrated into a part under the grounds of irrationality. Proportionality speaks mainly of what official decisions government bodies were aiming to achieve and the means of which they used to achieve it. Essentially, it is assumed that administrative actions ought not to go beyond what is necessary to achieve desired results. A case in point would be the Crown against Barnsley Metropolitan Borough Council ex parte Hook, where the Court of Appeal held that the punishment imposed on a market trader was altogether excessive and out of proportion. In other words, we could use the common saying that using a sledgehammer to crack a nut. Again, we must reiterate that rationality is not concerned with the decision being wrong, but rather it being unlawful, as the means employed to achieve it were excessive and out of proportion. The jurisprudence of the doctrine of proportionality is able to keep a good regulation on governmental powers, and this was expounded by Michael Foreman in the Judicial Review Handbook, as he imposes a duty upon the state to convincingly demonstrate that the response in question was appropriate and necessary to achieve a legitimate aim. Which we see the regulation of governmental powers would be through the test of proportionality. In the case of the Crown against Secretary of State for the Home Department, the House of Lords provided a three-part test. First, whether the objective is sufficiently important to limiting a fundamental right. The second, whether the measures taken are designed to meet the objective and rationally connected to it. And the third part being whether the means used to are no more than is necessary than to achieve its objective. As the grounds of proportionality are highly relevant to the Human Rights Act of 1998, we also are able to see regulation of governmental powers, as the courts will be legally obliged to and constrained by the Human Rights Act. This was clearly seen in the case of the Crown against Ministry of Defense ex parte Smith, where the claimants were unsuccessful domestically, but when they petitioned to the European Court of Human Rights, the appeal was allowed.
However, on the flip side, irrationality is also viewed as one of the more controversial grounds of judicial review, as it encroaches into the review of the decision itself rather than the review of the decision-making process, which is the concern in judicial review. It can be said to go as far as challenging the public body's decision when there is reason to believe that no decision maker from the point of view of a reasonable man would ever make such a decision. This may go beyond the limits of their power of ensuring that public bodies act within the law and may breach the doctrine of separation of powers, as Parliament has conferred the power to make the final decision on the public body and not the courts. In some irrationality cases, the courts or the judiciary may actually usurp the power of the public body. Context is a crucial factor when determining the level of judicial intensity that is to be applied in reviewing irrational decisions. In the Crown and Secretary of State for Education and Employment ex parte Begbie, Lord Justice Laws went on to say that the level of judicial intensity by the courts depends on the nature and gravity of what is at stake. When the matter at hand involves national security or national economic consideration, the courts will be more reluctant to interfere, as those issues fall within the context of politically controversial policy areas, mainly under ministerial control. This view was further supported in the Crown and Ministry of Defense ex parte Smith, where he noted that the courts will be more cautious and are hesitant to apply the ground of irrationality to a decision when the decision involves policy content and is a remote subject matter of a decision from ordinary judicial experience. Furthermore, in practice today, it is not easy for those who raise a judicial review application to succeed. This is due to the threshold that needs to be crossed being set at a very high level by the courts. This was set in place due to the issue of how close irrationality comes to reviewing the merits of the decision of a public body. As Justice Stuart Smith said in R and Police and Crime Commissioner of Lincolnshire, the court must not interfere simply because it thinks that it would have made a different decision if it had been the primary decision maker. Yet, when a court says that a particular decision is so lacking in rationality that it ought to be quashed, it takes the court perilously close to a review of the merits of that decision. This may result in judicial review being quite ineffective in certain instances. An indication of the level of absurdity required was pointed out by Lord Justice Warrington in Short and Poole Corporation, who stated, "I suppose that if the defendants were to dismiss a teacher because she had red hair or for some equally frivolous and foolish reason, the court would declare the attempted dismissal to be void." Another case where the ground of irrationality was raised unsuccessfully is the Crown and Home Secretary ex parte Brind, where the House of Lords held that the minister's decision to direct broadcasters to refrain from broadcasting words spoken by individuals representing organizations proscribed under terrorism legislation was irrational. However, when faced with an issue regarding human rights, the courts usually have no problem reviewing the matter in an intensive manner, making judicial review very effective in this sense. This was addressed by Lord Bridge in Bugdecay and Secretary of State for the Home Department, where he states that when an administrative decision challenges an individual's right to life, there will be a higher level of scrutiny practiced by the courts. A similar view was shared in Ex parte Smith. The courts place more importance on application with a human rights context, and that the greater the interference with human rights, the more justification the court will require on the part of the decision maker. In any event, however, according to Sir Thomas Bingham in Ex parte Smith, the test of irrationality was sufficiently flexible to adapt to an application with the context of a policy matter of fundamental human rights. There is a justification for irrationality on the following basis. First, it is likely that an irrational decision was the result of a faulty decision-making process. Second, a very high threshold has been set by the courts for irrationality. A decision cannot be interfered with by the courts just because they simply disagree with it, unless it is determined that no reasonable body could have come to that decision and it is in fact an absurd one. And third, when reviewing an irrational decision, the courts are only exercising a secondary judgment, as primary judgment is exercised by the public body. The following are successful cases where judicial review has been effective on grounds of irrationality. In the Crown and Swindon NHS Primary Care Trust, the Court of Appeal held that the trust's policy in relation to funding of a drug was irrational. In the Crown and Leeds City Council, the granting of retrospective planning permission relating to industrial filters was deemed irrational. Bradley, in which the Court of Appeal held that Secretary of State for Work and Pensions had acted irrationally in rejecting a finding of maladministration by the Ombudsman.
Now, moving on, we'll be talking about the third grounds of judicial review, which is the procedural impropriety. Basically, procedural impropriety is one of the grounds of judicial review in which the public authority commits a procedural error in making decisions. In order to fully examine how effective on this particular ground of judicial review in ensuring that the public authority acts within the law, it is important to have a rough idea on how procedural impropriety is governed. It's basically governed under two authorities, namely the statutory requirement and the common law requirement. There are two types of requirement under the statutory, namely the directory requirement and the mandatory requirement. Directory requirement is a less fatal requirement which may not invalidate the decision taken. However, mandatory requirement is an essential requirement where failure to comply with procedures laid out by the statute may render a decision invalid, which can be seen in the case of Bradbury and Enfield London Borough Council 1967. In that case, the decision was quashed as the council failed to obey the requirement under the Education Act 1979. As previously submitted, governmental body can be subjected to judicial review on grounds of procedural impropriety when they do not adhere the common law requirement, which is the rules of natural justice. There are two doctrines associated with natural justice and must be fulfilled in order to achieve and to make sure that the public authority act lawfully and fairly, and most importantly, do not abuse their power. When the decision-making process is not in compliance with the doctrine, they will be subjected to judicial review. The first doctrine associated with natural justice would be the doctrine of Nemo Judex in Cosa Sua, which is the rule against bias. The second doctrine will be the doctrine of Audi Altera Partem, which is the right to have fair hearing. First, we'll be elaborating the first doctrine, which is the rule against bias. Basically, there are three types of bias, namely the actual bias, apparent bias, and presumed bias. A real-life example of actual bias is when the governmental body refuses to issue passport to a particular person because he has taken a personal dislike to him. Next, apparent bias is governed under the modern test set up by Lord Hope, which is whether a reasonable person will conclude that there was a real possibility of biasness present. Next, under the presumed bias, A decision maker will automatically be disqualified if he has a direct financial or pecuniary interest in the outcome of the decision, as no man should be judged in his own cause. This can be seen in the case of Dimes and Grand Junction Canal Limited. In that case, the judge held share in the company involved in litigation. The House of Lords set aside the decision and stated that it is of the last importance that the maxim that no one is to be judged in his own cause. However, this does not apply in all situations, as seen in the case of Bromley London Borough Council and Greater London Council. In that case, all the judges in the Court of Appeal were themselves both taxpayers and the users of public transport. However, this did not disqualify them from hearing the case. Now, we'll be talking about the second doctrine, which is the right to a fair hearing. It is protected under Article 6 of the European Convention of Human Rights in ensuring that the public authority acts within the law. So, example of requirement of fair hearing includes the right to submit evidence, the right to a legal representation, and the right to reasons for a decision. So, in the case of Reach of Belvin, it is a classic case to show that failure to conduct a fair hearing would render a decision being ultra vires. So therefore, the decision will be invalidated. Moving on, we'll be talking about the duty to give reason. A decision-making body is under a general duty to give reasons. However, there are also some exceptions in the sense that not all bodies are dutifully obliged to give reasons on the basis of fairness, as stipulated in the case of the Crown and University Funding Council. However, this can be contrasted in the case of South Buckinghamshire and Porter, where it was provided that decision must be intelligible and they must be adequate and must not give rise to substantial doubt or by law made by the decision maker. To elaborate this, the decision-making body must ensure that the reader understands why the matter was decided in that manner. Next, we'll be talking about legitimate expectation. A legitimate expectation arises when the public authority misleads the claimant that certain procedures will be followed in reaching that decision. So once legitimate expectation has been established, the claimant can seek for judicial review. This can be seen in the case of the Crown and Liverpool Corporation and ex parte Liverpool tax fleet. In that case, the corporation had given an express representation that license would not be revoked without prior consultation. This created a legitimate expectation which could be relied on when the corporation failed to carry out that consultation.
There are several remedies that are provided. There is a prerogative order, equitable remedies, and the common law remedies. Under the prerogative order, we have quashing order, prohibiting order, and mandatory order. So these remedies are all discretionary, which means that the courts can choose not to actually give remedies if they do not feel it feasible. It is all up to them, and they are able to decide based on their administrative decisions. The discretion of the courts in deciding whether to grant any remedy is a wide one. It can take into account many considerations, including the need of good administration, delay, the effect of the third party, the utility of granting the relevant remedy. The discretion can be exercised so as partially to uphold and partially quash the relevant administrative decisions or the act. This was actually stated by Lord Justice Hobhouse in Credit Suisse against Allerdale Borough Council. A quashing order is formally known as a certorial. It quashes an unlawful decision. For example, in the case of R against Ware Valley Council ex parte Binks, Binks had successfully obtained an order to quash an unlawful decision. This was made without a prior notification or accompanying reason to Ware Valley District Council, and that she could cease the trading. It allows a fresh decision to be made by the public body. In relation to delegated legislation, in the case of R against Secretary of State for Health ex parte United States Tobacco International Inc., the court quashed the oral snuff, which is a safety regulation 1989 act, and it made by the Secretary of State for Health, on the basis that the claimant had not been given the opportunity to make a representation before they were enacted. The second type of remedy being under the prerogative order, which is a prohibiting order. This order is formally known as prohibition. It is preemptive in the sense that it prevents a body from acting unlawfully in the future. A prohibiting order focuses on the future and orders the public body to refrain from acting in a way which would breach the law. It is used most frequently in relation to asylum and immigration claims. In the case of R against Liverpool Corporation ex parte Liverpool Taxi Fleet Operation Association, it was preventing a council from granting further taxi licenses without first hearing the representation or interested parties. A PO was granted, basically a prohibiting order was granted to prevent the authority acting on this invalid decision to allocate taxicab licenses.
To continue with remedies, this order, a mandatory order, formerly known as mandamus, compels a body to act, that is, to perform a statutory function. Mandatory order requires a public body to act in accordance with the law and its statutory duties. In the case of Padfield versus Minister of Agriculture, Fisheries and Food, the minister had the power to refer complaints about the operation of the Milk Marketing Board scheme to a committee. He refused to refer a complaint of substance to the committee. The House of Lords held that an order of mandamus should be made directing the minister to consider Padfield's complaint according to the law. An injunction is the next remedy. The equitable remedy can compel a body to perform or act or restrain it from doing so. Injunctions can either be prohibitory or mandatory. Injunctions are available in both private and public law and allow a court to issue instructions to prevent the infringement of a person's legal rights. They're not often used in judicial review because they are so similar to prohibiting orders, but they are useful where the claimant is seeking interim relief. A declaration is the next remedy. A declaration simply declares what is the legal position between the parties and provides no specific relief to the claimant beyond that. It might seem like rather a strange remedy in that it does not compel any particular action, but it is useful as it lets the public body know clearly the legal position. They are used in relation to the central government on the basis that ministers can be assumed to abide by declarations. This equitable remedy is non-coercive as it presents a formal statement of the law by the courts. Damages is a common law remedy and it has not been historically used as a freestanding remedy as it had to be combined with another remedy. In practice, to claim damages, a claimant was required to show that the unlawful public law decision was also, for example, negligent. Damages in conjunction with any other remedy are available by judicial review. Part 54 of the Civil Procedure Rules provides that a claim for judicial review may include a claim for damages, restitution, or a recovery of a sum due, but a claimant may not seek such a remedy alone. The award for damages is possible, but rare. The focus in judicial review claims is on stopping unlawful decisions being made or quashing unlawful actions rather than on compensation for losses. And those are the remedies available for judicial review.
However, there are some matters which are non-justiciable, meaning that judicial review does not apply to it. Cases in point would be Nottingham County Council and Secretary of State for the Environment and also CCSU. In CCSU, the House considered an executive decision made pursuant to powers conferred by a prerogative order. The minister had employed employees at GCHQ not to be members of trade unions. It was held that the exercise of a prerogative power of a public nature may be, subject to constraints of national security and the like, as susceptible to review as that of a statutory power. The controlling factor in determining whether the exercise of a power by a body is subject to judicial review is not in its source but its subject matter. Challenges to the lawfulness of subordinate legislation or administrative decisions and acts may take under the headings of illegality, procedural impropriety, and irrationality. In the case of Secretary of State for Foreign and Commonwealth Affairs ex parte Rees-Mogg, the ratio was the applicant, a former editor of the Times, sought judicial review of the decision by the respondent to ratify the EU treaty, saying that it would increase the powers of the European Parliament without it having been approved by Parliament and would transfer the royal prerogative power to enter into treaties without parliamentary approval. It was held that judicial review was refused. The 1993 Act had referred to ratification of the protocols and therefore Parliament had approved them. The Social Policy Protocol had been excluded from ratification and was not to be incorporated into domestic law. Domestic law was not therefore amended. Whilst the court had jurisdiction to consider the ratification of title of the treaty relating to foreign and social policy, it involved no question of domestic law. Next, we'll talk about ouster clauses. Legislatures may also seek to exclude or limit the application of judicial review by asserting certain clauses such as finality clauses, no certiorari clauses, as if enacted clauses, shall not be questioned clauses, or partial ouster clauses. In general, such clauses are not particularly effective as the court's approach is to ask whether the act in question is intra-vires. Since Annus Minute Limited and Foreign Compensation Commission, it is clear that even an intra-vires act can raise jurisdictional questions such as whether, in the course of exercising a properly conferred jurisdiction to rule, something was done which was beyond its powers. The court is thus left to determine whether the act is in fact intra or ultra-vires. So why would the government try to insert these sorts of clauses into a statute? There are many circumstances where people do not like their decisions to be questioned. Some of the reasons include it can be inconvenient and costly to defend allegations, it can slow down the decision-making process, and also it can be very embarrassing if it is found that the decision is unlawful. The key problem is that they limit access to justice. Ouster clauses prevent individuals from accessing courts even when they consider that they have been dealt with it in an unlawful manner by the state. The courts are, however, willing to accept provisions which restrict court jurisdiction to a limited time period, as seen in Smith and East LO RDC and R against Secretary of State for the Environment ex parte Osler. Some of the reasons include it can be inconvenient and costly to defend allegations, it can slow down the decision-making process, and also it can be very embarrassing if it is found that the decision is unlawful. The key problem is that they limit access to justice. Ouster clauses prevent individuals from accessing courts even when they consider that they have been dealt with it in an unlawful manner by the state. The courts are, however, willing to accept provisions which restrict court jurisdiction to a limited time period, as seen in Smith and East LO RDC and R against Secretary of State for the Environment ex parte Osler.
To an end of our constitutional law group assignment. I believe that we've successfully brought you through the definition of judicial review, the grounds of judicial review, and we've also shown you how effective those three grounds are in ensuring the regulation of governmental bodies. Additionally, we've also shown you a few disadvantages and critiques to the statement that judicial review is efficient in controlling governmental powers. Hence, conclusively, we as a group concur that judicial review is in fact efficient in controlling governmental powers.